SJC-12860 in the matter of an impounded case.
Mr. Hennessy.
Good morning, and may it please the court. Robert Hennessy on behalf of the juvenile in this case. I'd like to begin with the first reported question in this case, which is whether it is a violation of due process to conduct an evidentiary transfer hearing pursuant to Chapter 119, Section 72A, at which it will be determined, one, whether there is probable cause to believe that a now adult defendant engaged in criminal conduct years earlier as a juvenile, and two, if so, whether discharge is nonetheless consistent with the protection of the public, while the object of that proceeding has been determined legally incompetent to stand trial. The appellant is asking this court to answer that question in the affirmative and hold that conducting a hearing in such circumstances violates due process as a matter of law because it creates a grave risk not justified by countervailing interests of erroneously depriving incompetent defendants the prophylactic benefits that Section 72A is designed to provide. I think a good starting point for this discussion would be the competency to stand trial standard and sort of what a finding of incompetency suggests. As a general matter, a competency to stand trial requires that an accused be able to A, understand the nature and object of the proceedings against him, B, to consult with counsel, and C, to assist counsel in preparing his defense.
You need to distinguish between your situation and bail and 58A proceedings, correct?
Correct. Yes. In Torres, I believe, this court addressed the bail issue, whether or not a bail proceeding can go forward while a defendant was incompetent, and in Abbott A, the 58A proceeding was addressed by this court.
So how is this different?
Well, with respect to bail, the inquiry at a 72A hearing is in no way simple in the way that a bail hearing inquiry is. In Torres, this court held that one of the reasons that a bail hearing could go forward while someone was incompetent is because the facts themselves are rarely in dispute. They're simple, they're straightforward, they can be presented by counsel without creating a huge risk of an error in that case. In a 72A hearing, that is not the case at all.
Is one distinguishing factor is that in 72A hearings, they can be dispositive?
I'm sorry?
It can be dispositive.
72A hearing can be dispositive, unlike bail.
It can lead to discharge.
Yeah, the liberty interests at stake are much greater in a 72A hearing. I mean, clearly, if an error in bail results in pretrial detention that shouldn't have occurred, that is a significant liberty interest. But here, this in a 72A case where you're dealing with allegations of juvenile conduct brought against an adult defendant, that could be the entire game. What needs to be figured out is A, is there probable cause, and that determination has to be made under the directed verdict standard of probable cause, not the grand jury standard of probable cause, in which hearsay is not permitted at the hearing. There's an opportunity to cross-examine your accusers. These are all very different than the inquiry. And then in terms of the discretionary decision as to whether or not to discharge or to dismiss, and the terminology is a little odd, but dismiss into the superior court, that's essentially an unlimited world of facts that could inform that discretionary decision for a juvenile court judge.
Standardless, isn't it at this point? It's standardless?
It is. The second prong is standardless. The first, the probable cause is the directed verdict standard, but there are no standards.
Varies from judge to judge. Varies from judge to judge, case to case.
It could vary from judge to judge. I think the fact that there's no standard, it would be impossible to track how it travels from judge to judge.
Why should you get a dismissal as opposed to 16F relief? Because your case is very much unlike Sharis.
Yeah, so what my principal argument with regard to, okay, so assume for a moment you can't go forward with the 72A hearing, we're stuck at that point in the case. My principal sort of due process / equal protection position is that insofar as 16F does not apply to juvenile proceedings, which this court suggested in Abade, it might not, because Section 16 talks in terms of criminal convictions. There should be at least that those protections for people who are in juvenile court indefinitely because of incompetence.
I guess one of the problems I have with that argument is the nature of the evidence in the competency reports, certainly by the juvenile expert, because it kind of shows that your guy is very much unlike Sharis, in that Sharis had an organic issue, was never going to be competent, and was not a danger. Your person is on the cusp, I would say, of competency.
Sure, and I'm sorry if
probably could be restored to competency at some point.
Yeah, and my argument is not that there should be an immediate dismissal. I'm just saying that there should be some remedy at some point if competence is not established. If someone does not gain competence, and that'll be determined, presumably by checking in periodically, subsequent reports. I'm acting on the assumption that as of right now, there's been a determination of incompetency based on that recommendation from both the defense and the court clinician on behalf of the Commonwealth that this person is currently incompetent.
But you think 16F is just too long?
No, I think that if this court held that the 16F, either on its face or through application of equal protection, applied to people in this position, I think that would be a sufficient protection in this context. So, dismissal as a matter of right once half of the time to parole eligibility has elapsed, and dismissal as a matter of discretion in the interest of justice whenever that makes sense, because that's the other part of 16F. That would be my position with regard to that.
Your sister makes an applied argument that, to use Justice Gaziano's formulation, he's on the cusp of competency.
Yeah.
Could we do that here? Because, I mean, he did manage to get himself a job. He functions independently in certain ways. He's not our typical incompetent defendant.
Yeah, well, I think that our position is that the dispositive standard of mental competence should be the traditional standard of incompetence to stand trial under Dusky and Drope and Vallis and all of those cases, the standard I discussed earlier. I think the problem with an as-applied analysis is that it's predicated on separately addressing the extent and nature of incompetency under some different and, I guess, presumably lower standard than Drope's.
We've already gone there a little bit, though, haven't we? We've done that. We're a little bit, we've gone down that road somewhat, right?
Yeah, certainly, and I think that the way that, my understanding of the way that has come up in the cases is that beginning in 1997, when this case decided the Hinnant case, in which this court held that it would be categorical violation of due process to hold extradition proceedings while someone was incompetent. The facts in that case, which I don't think were dispositive to the holding, but the facts of that case were that the person, Mr. Hinnant, was suffering from some sort of closed head injury that made him, as I understand it, actually nonverbal, like he literally couldn't speak. And then as we come forward, fast forward maybe 10 years, and then Torres is decided, and also the sexual dangerous persons cases are decided. And distinguishing Hinnant, I think this court has said, well, this person is different than Hinnant in the SDP cases and in the 58A case in Abade as well, and suggests some relevance to the nature of the incompetency, to the inquiry under the due process clause. But as I read those cases, what was driving them more than anything else is the government's interest in prospectively protecting against threats to individuals or public safety.
But I guess, can we, given that we've gone down that road a little bit, can we still reach the result you want here, saying, look, particularly the second part of this 72A inquiry really requires a fully engaged defendant. Can we still do this applied analysis there, or is it we have to revert to the all or nothing, which I think you argue in your brief.
I believe that reverting to the all or nothing is what is necessary to have predictable, consistent results consistent with due process.
But in your reply brief, you're suggesting, however, that because the individual stands charged with a nonviolent sex offense, that somehow that makes a difference. So are we to look at this on the basis of how seriously the crime is to a danger to the public?
No, I don't think that.
Like that.
I don't think the seriousness of a crime is a good way to determine the due process rights of defendants. What I think is,
Well, don't you
insofar
have to weigh the Commonwealth's interest in public safety?
I'm sorry, I didn't.
Don't you have to weigh the Commonwealth's interest in public safety?
You do.
So how do you do that if you've got a serious violent crime?
My point is that you have to weigh the Commonwealth's interest in public safety as it applies to a 72A hearing, which is what we're here to talk about. And my position is that a 72A hearing is not designed, nor does it in effect address the public's interest in ongoing public safety risks. My argument is that insofar as those exist, you can go forward with a...
I thought the due process part of 16F weighs public safety.
Sure, yeah, no, if you get to the point where you're not going forward with the 72A hearing, you can consider public safety at that point, just as a general, I think that...
For ultimate dismissal.
Yeah, absolutely. But
And the Commonwealth here could arguably pursue an SDP proceeding against him.
they could pursue an SDP proceeding in a case involving a sex offense. They could pursue a dangerousness detention in cases that have that as a predicate offense. And they can even, not directly, but through the court clinic, pursue civil commitment as well. I mean, they don't have the standing to bring the petition, but they could try to vindicate those interests through that method. You know, I mean, if we're going to get into the facts of this case, I mean, I think it's important to recognize that there's never been any suggestion that there's an ongoing threat of safety from this person. This person was released on recognizance. There were no efforts to even impose bail. There was nothing in this case.
There's a stay-away order?
I believe there is a stay-away order, but this is a case where these people, I guess, wouldn't have come into contact for nearly a decade, because this is a decade-old allegation.
So you can proceed in an SDP,
Yes.
and under Nieves, you can do that even though the person's incompetent.
Correct.
Right? And that's a pretty complicated inquiry, right?
It is.
So, but you're saying you can proceed under an SDP even though they're incompetent, but you can't proceed here when they're incompetent. And why is this inquiry more difficult or more? Why does this inquiry require more involvement of the defendant than that one?
Well, I think that with regard to the determination of probable cause, it's probably pretty similar.
Right.
With the exception that SDP proceedings have a higher standard of proof for the government, which is proof beyond a reasonable doubt. With respect to the discretionary decision as to whether or not to discharge the case or to send it on to adult criminal court for prosecution there, I think that the limitless nature of the facts that could inform that decision, the fact that 72A itself is sort of a prophylactic provision which takes into consideration the natural desistance when people go from being a juvenile to being an adult, that the work of the juvenile court may have just been done naturally by maturation. I think that there's just such a huge universe of facts that might, I think as this court discussed in the case involving transfer of statutory rape as a lesser included, which I believe you authored, Justice Kafker, there can be a tension between the first and second prong because the discretion is so broad to dismiss under the second. So you could essentially be called upon to strategically decide whether to maybe even to concede probable cause or testify to put on evidence that would inform the second prong.
Could the judge take into account in the second prong the nature of the crime?
Yes, I think that can be dispositive under the second prong. I think this court has held
So
that
the
that's
level
enough.
of danger to the public could be taken into account by the judge then?
Yes, under the second prong of Section 72A, it can.
Okay.
Can you even do the second prong with an incompetent? I mean, I'm just trying to figure out how you would possibly do the second prong while the defendant is incompetent.
I think it would be very difficult. I think, and I would point you to the amicus brief, which provides, I think, a very valuable sort of firsthand narrative description of what's happening in these competency determinations from the point of view of a lawyer who's tasked with doing them in front of a juvenile court, and all the problems that incompetency is going to create in order to zealously advocate on behalf of your client in this context.
All right, thank you.
Thank you very much.
Ms. Johnston.
May it please the court, Tara Johnston for the Commonwealth. Your Honors, it is the Commonwealth's position that a balancing of the three Matthews versus Eldridge factors, the government's interest, the private interest, and the risk of erroneous deprivation of the private interest if the proceeding is to be held, leads to the conclusion that it is not unconstitutional per se to hold a Chapter 119 72A proceeding.
So
Yes.
can we start where we started with counsel, Mr. Hennessy, where this court has said that bail, 58A, can go forward with an incompetent defendant, but nothing else so far. This is a dispositive hearing. It can lead to discharge of the juvenile. Why is this different?
Well, certainly, Your Honor. Well, a 58A hearing could lead to temporary, at least, discharge of the person as opposed to custody. An ST
No, I meant by discharge, I mean
Oh,
case goes away,
yes,
discharge.
Right. So
in-
that
in
yes.
the unique
So,
part of a transfer hearing.
right. So yes. So in the sense that the individual certainly has a very weighty interest in that, of course, but at the same time, the Commonwealth has an important interest in actually being able to pursue this case. And actually, if you look at the private interest in, say, a 58A hearing or an SDP proceeding, that is dispositive in the sense that the person is going to be held in custody.
The SDP is a civil proceeding, right?
Yes, yes.
And 58A, by its terms, ends after 120 or 180 days, depending on where you are.
Well, that depends not if you're dealing with someone who's incompetent. If you're dealing with someone who's incompetent, it could go much longer than that. For a juvenile in juvenile court, it could go up till the person's 21 years old, so depending on when they're apprehended. But for an adult in adult court, 123.16F would kick in, at which case they could be held up to half of the maximum sentence when they would be eligible for parole.
Well, then, I guess, then we get into the whole due process issue. It depends on how incompetent they are and whether it's organic or not organic, right?
Correct, Your Honor. But the argument that it's not as one of my brother's arguments is that the individual has a much more weighty interest here, and I don't think that's actually accurate because when you look at the interest in the individual's interest in, say, a 58A hearing or SDP proceeding, that could actually lead to custody or commitment, whereas that is not the goal of a 72A proceeding.
Yeah, I know that, but here's the thing with the 72A hearing is that second prong is so spongy. Don't you need the person to be able to really just sort of prove in a way to the judge or satisfy the judge that somehow things have changed. He's a reformed person, or he's on the right track. For the judge to say, well, listen, really, public interest doesn't really require prosecution. And how do you do that with somebody who's not competent?
Well, I think. So,
Whereas, I guess my point being with that, I'm sorry to interrupt, but my point with that was that it seems to me like the bail hearings and the SDPs are more rigid in terms of, more constrained in terms of principled decision-making.
I don't know. I think that one of the things that you take into consideration, even the factors laid out in Torres of all the things the mitigating factors, all the factors the judge is to consider in terms of even a bail hearing in Commonwealth versus Torres, and you have all these factors the judge is to consider. Same application in a 58A hearing. I think those can adequately be represented by defense counsel. Now, of course, it will depend on the case. The Commonwealth is not suggesting that in every case it will be permissible or constitutional to go forward.
What about gathering facts? So
Well, a lot of that will be dependent upon, say, what we're relying on right now, which is the psychological reports, evidence of what the individual has done. For instance, based on the psychological reports here, we have a lot of information about this individual, about his capacity, about that he can function independently, about the nature of and the extent of his incompetency. Now, of course, every time it will be a fact-based determination. but that it's not something, there's no reason to think that defense counsel would not be able to adequately represent the interests of the individual and present reasons, mitigating factors as to why it would not be in the public interest to go forward. There will be certain cases that it will be impossible to do so because of the extent of the individual's incompetency. And the Commonwealth understands that, just as that's the situation in a 58A proceeding or an SDP proceeding. What the Commonwealth's argument is that it's not unconstitutional per se.
Why can't you wait? I know why you can't wait with regard to bail. You have to figure out what's going to happen to him awaiting trial if he's not to be held in civil custody. And I know why you can't wait for a dangerousness determination, but why can't you wait here? You can't try the case anyway.
Correct, Your Honor. Well, aside from the fact that the Commonwealth always has an interest in bringing cases to justice, because you're right, we cannot try the case at the moment
Right.
anyway.
So it's not going to hasten anything. You still have to
Right.
wait till he's competent before you can try the case.
Of course, but we also have an interest in public safety, and we have an interest, and so that is why
How is that served? You could pursue a dangerousness proceeding here, or you could pursue a bail hearing, or you could pursue an SDP.
Well, so I think there's a lot of questions here, a lot of open questions. Number one, so I don't think it's completely clear, first of all, that we could not petition for civil commitment under 123, Section 16B, and in conjunction with Section 8. I think it's still an open question as to whether we could. But that is a standard we would have to meet beyond a reasonable doubt.
Well, let's assume you can. Let's assume you can.
Let's assume you can. Okay, so that would be a standard that we would have to meet beyond a reasonable doubt. It's completely not clear that we could actually move for SDP on someone who is not being held in custody. The case that my brother cites, Commonwealth Koran, is a situation where the person was being held in custody. 123A, this court has held, the statute itself states it, and this court has held in Commonwealth versus Gillum and Commonwealth versus Libby that the triggering offense is that triggering event is that somebody is actually held in custody, and then the Commonwealth moves on that. It is not at all clear that a person who has just been arraigned in a 72A setting, the Commonwealth can move to petition them as SDP.
Well, not as SDP, but perhaps under the remainder of the civil involuntary commitment statutes. Would that work?
It's possible. According to my brother's reading of 123, Section 16B, and according to the juvenile court judge's reading of it, the Commonwealth, what opens up the door for the Commonwealth to petition for civil commitment in this case is the case being transferred. It is not clear from 123, 16B whether that is the case or not.
But if you prevail,
Yes.
okay, then there's a prompt hearing as to 72A, and let's assume that the judge says, I'm not going to discharge it.
Right.
Then you sit and you wait in criminal court until
correct.
the matter. So
correct, but
wouldn't the judge be in a better position to decide the second prong, the discretionary prong, at a time in which, wholly apart from the capacity of the defense to argue the discretionary piece, but if it may be 2 years before he's competent, wouldn't we want a judge to be making the 72A determination as to whether to discharge at a time when it's ripe, as opposed to a time that could be years before it's ripe?
I think the problem becomes how much jurisdiction does the juvenile court have over the case until that point. And I think this court has made very clear in Commonwealth versus Nanny and Commonwealth versus Mogolinsky that the juvenile court's jurisdiction over the case under the way the legislature has set out the statute is that the legislature envisioned, and 72A wasn't acted as a protective measure for the individual, but is that the person is arraigned, and then soon after, the 72A transfer hearing is held. The statute itself doesn't envision the scenario where this person is incompetent, and obviously if it did, we would not be here, but where the person is incompetent and we do not hold a 72A transfer hearing at that point. The question then becomes, what jurisdiction does the juvenile court have over this individual until that time? And it's not clear.
I'm sorry, so I'm perplexed. Are you worried that if we say you don't do a 72A hearing until he's competent and 2 years passes, so he's now then, 25, that the juvenile court says we no longer have jurisdiction?
No, right now the juvenile court doesn't have jurisdiction. I mean, right now it's not clear how much jurisdiction the juvenile court has.
It has enough to decide the 72A issue.
It's enough to decide the 72A issue, but the court in Mogilinski has been very clear that that's a very limited, it's limited to that. I mean, that is, this court has held
But somebody
that-
could be 40 years old, couldn't they? And then the discovery was that they did the crime when they were 16?
Yes,
Doesn't the court still have jurisdiction over that person to decide on his
just for the purpose of 72A
Yes,
transfer
right,
here.
but the passage of time alone isn't the key thing, right?
No, the passage of time isn't the key thing, but it's not clear. This court has said that that if the legislature intended to expand the jurisdiction of juvenile jurisdiction, then it would have said so. So the juvenile,
And why this is, I guess my problem is I don't understand why it expands the jurisdiction of the court.
it's not clear what jurisdiction, it's not even clear, at least it wasn't clear to the motion judge, and my brother seems to argue that the Commonwealth cannot even move for civil commitment on this person. So it's not clear what jurisdiction the court has when they're at gap stage. There is certainly an argument out there that my brother is certainly arguing that the Commonwealth can't even move under Section 123.16b in conjunction with Section 8 for civil commitment. It's also not clear how moving for, imagine a scenario where we have a crime that does fall under 58A. And actually, I do want to correct something here, because the crime here would fall, even since Vieira and Sion, the crime here would fall under 58A because it was a household member. So I do want to correct that.
I just want to make sure I understand. You say we need to decide this because in this limbo period, the court, you're not able to act. But if we decide in your favor, then you can move forward with SDP stuff and other things. But if we don't decide in your favor, he's in a limbo stage and none of this stuff can happen. Is that your argument?
I'm not saying that none of this stuff can happen. I'm saying that it's ambiguous and that it's just, we do not know. We're in a...
If we solve that for you, are you fine?
Yes. Yes,
okay.
absolutely. Yes, if this
Your
court...
real problem is the ambiguity of what's happening in this period of time.
Absolutely. I also think, I'm fine. I also think, though, that the balancing of the factors do weigh out similarly to Abbott A and Neves. So I think that those cases suggest that it would be, the balancing of the parties do suggest that it would be constitutional. But yes, I think the bigger problem here is, if this court holds that it's unconstitutional, what do you do? What rights does the Commonwealth have? Can the Commonwealth move for civil commitment? If the Commonwealth, say, is in a 58A dangerousness situation where the Commonwealth does want to move for 58A, what is the durational limitation
let's
of that?
pose that to you. So we rule against you. We say that the second stage is too discretionary and too complicated, and you've got someone you consider dangerous. What do you want us to say that you can do? Do you want us to make clear that you can bring an SDP proceeding in this context? What do you want us, I'm trying to, if you were writing this part to clarify this, what would it say?
I think it would say, ideally, that it would set a, so if, say, that we move for dangerousness, it would say a durational limitation.
Talk very quickly.
Well,
So say that again.
it would have to
Could
set
I
a
just
duration.
want to make sure I understand what you're saying. Sorry, go ahead.
No, so, yes, so say we are allowed to proceed on a 58A dangerousness proceeding.
Right.
This court would set a durational limitation as to when that would end. For in juvenile court, we know that it would end at the period for a juvenile at 21 years of age. And then if the Commonwealth wanted to proceed after that, the Commonwealth would have to move for civil commitment. We know for an adult, in adult court, the provisions of 123.16f would apply. So it would be up to, with regular periodic checks, of course, it would be up to half of the maximum sentence.
Okay, but
the
again,
person can serve.
say we agree with you that you're right, that 16F would apply.
Okay.
But there's still this gap period between competency, he's incompetent and he's in this gap period. What do you want to be able to do that you're not sure you're able to do to protect the public from someone you consider maybe sexually dangerous? I'm just trying to, because there's that gap period. That's a year. That's a 4-year, 5-year period for these offenses, right?
I think that we are able to first of all, to move for 58A, and we have a way of we know we can, in a situation where a 72A proceeding is going to happen, presumably, but to set a way to actually apply it so that there is a durational limitation, so it makes clear. So say 16F does apply to those situations. And then in that we can move, if we can probably prove beyond a reasonable doubt that there's a likelihood of serious harm, that the Commonwealth does have the opportunity to do that by moving for civil commitment under 123 Section 16B.
58A is only going to get you so far, though, because even though the incompetent period is excludable delay under Rule 36, so it wouldn't count for the 120 or 180 days, there's a certain point under 58A where somebody's held where you're going to have a due process issue come right back.
And the court, and then there's, and Abbott A deals with that. Abbott A addresses that. And in a juvenile situation, it would be up to when the person's 21 years old, or the Commonwealth would have to move for civil commitment. For an adult court, then it would be the provisions of 123 Section 16F would apply. It's just not clear that those apply in this circumstance. And unfortunately for the person in the appellant's position, that would almost be depriving him of something. It would be depriving him of the opportunity to prove that there's not probable cause for the charges, or that it's not in the interest of the public to pursue this, and instead a provision that is meant for adults in adult court where the court has already found that a complaint has issued or an indictment has issued, that would be being applied to him. And to some extent, that would seem like it's worse for individuals in the appellant's position than actually better. So to some extent, it's actually more beneficial for the appellant to actually have this procedure where the judge can decide, even if there's probable cause, it's not in the interest of justice.
I think Mr. Hennessy might disagree on what is beneficial for his client.
Yeah.
And again, I'm not talking, so taking aside this specific case, I'm talking as a general matter. As a general matter, it might be more beneficial to certain appellants.
This is very interesting, but I don't see this in your brief. Is this in your brief?
I didn't get to the point where I discussed the whether or not, I do argue that it's not clear whether or not 123 Section B applies, Section 16B applies. I do argue that. I do not argue the concerns about the 58A. So I have not argued that, and I also, it was only in my brother's reply brief that he argued about moving for SDP on the person. The Commonwealth's position is that it's not clear that you could do that under 123A.
So in a nutshell, do I understand your argument to be that if we are to say that the determination of whether this is to be a criminal or proceeding or is to be dismissed is to be delayed because of incompetence, while that decision is awaiting, you want him to be treated as if it's a criminal matter in terms of these particular proceedings? That is, you want 16B to kick in, you want 58A?
I think that would be necessary to protect the Commonwealth's interest of not just bringing cases to justice, but also to protect the public safety. Again, in certain cases, leaving aside the facts of this case or whether or not this particular person poses a risk to public safety, which I think based on the allegations of the underlying crimes, it would suggest that he does. But leaving aside that for a moment, there are going to be, we can envision a scenario where someone was committing rapes between the ages of, while he was 16, 17, is then apprehended the day after his 19th birthday. That person certainly is a serious public safety risk. And if we just say, okay, well, because this person is this limbo stage, we can't really do anything, that really ties the Commonwealth's hands. But if we say, okay, the Commonwealth can move for 58A, and we have this durational limitation on that, or we're going to apply 16F for it, the Commonwealth can move for civil commitment under 123.16b, and we have these periodic reviews, as this court held in Abbott A, the court exercised superintendent's power under 211.3 to have periodic reviews every 90 days. I do not think it would be as problematic. But I think the problem is that there are just so many open questions here. And I think those open questions would have to be addressed. I do think that the balancing of the factors, as the Commonwealth argues in its brief, do weigh in favor of the same conclusion that is in Abbott A and in Neves, but if this court finds it does not, then those answers need to be addressed.
Okay, thank you.
Thank you.
We'll take our morning break.